Hello and welcome to Franchising Uncut, a spin-off of the BDC's Tell Us Your Effing Story podcast series. Franchising Uncut is a series of interviews with leaders in the franchise and retail sector, where I'm your host, Bruce McFarlane. I'm here with Alexia White, who's an Associate Director of BDC Law. Welcome, Lex.
Thank you, Bruce. Nice to be here.
Today we're going to do a deep dive on estate planning, a little bit different to a lot of the franchising related topics, but it's something that's obviously very relevant for franchisors as owners of businesses and how they look after themselves. So when people think about estate planning, they think of their will and maybe of a power of attorney or something like that. And it's maybe something like when you get older, like it's hard. It's not something that, young like you, Lex, it's not something that your generation are even thinking about. But what about business owners? Like how should they approach this?
Yeah, that's right. So for most people, estate planning is personal. It's about home, your house, your savings, your super, and maybe some investments. And a will and a power of attorney will generally cover that. But for business owners, there's this other parallel world where your business operates, and often your business assets actually sit outside of your personal assets, and because you've received really great advice from your accountants and you've set up companies and trusts and other vehicles so that you're protected in your personal capacity. So what that means is that when it comes time to figuring out what you want to do, your will doesn't actually govern what happens to that business asset because it's sitting well outside of your personal estate. So what we need to think about is actually how your business is structured and who actually owns that and what documents we need to put in place to ensure that there's a succession plan. So ideally, the goal is that you're protecting your family and their financial future, that you're also preserving the continuity of your business that you've worked really hard to establish, and that you're managing tax and legal risks.
Okay. So it does depend very much on what your structure is. And so I guess at a franchisor level, the franchisor generally has at least one, multiple companies, potentially other partners in the franchisor entity. We'll leave out listed companies for the moment, but assuming they're private. So there's companies and sometimes trusts, sometimes unit trusts, sometimes discretionary trusts that own the franchisor entity. And I guess at franchisee level even, franchisees, depending on service-based ones, may be individuals, but probably unlikely. Most of the time it is a company. It might be, it's less complicated in terms of entities, but it's still normally a company.
Yeah.
So what sort of things, with companies and trusts, how does that interact from a personal point of view with the business structure?
Yeah, that's right. So as you touched on, that businesses can be operated as a sole trader, at probably more at the franchisee level. And so in that circumstance, yes, it's your will because you own everything that operates the business in your personal capacity. But if not, then you might own your business by way of a partnership. So there might be a partnership agreement that sets out what happens on the death of one partner. In a company, you own the shares and those can pass in your will. However, if you have a shareholders agreement, that could actually set out a completely different process of what happens in the event that you were to pass away or become incapacitated. That, in fact, could actually trigger a buyout. So in such a circumstance, you could have a will that says one thing, a shareholders agreement that says another, but it's that shareholders agreement that's actually going to override what your will says. So I'll say this again and I say this to lots of clients, doing your estate plan is not just let's focus on the will. We actually need to go back to the basics and foundation and figure out how all of your entities have been set up and what documents are in place so that there's no competing documents that can cause a headache for the people that you leave behind. The other thing is the trust. So in such a circumstance, you don't actually own the assets personally. They're held in a trust and you probably are the appointor. So you've got ultimate control over what happens, but you're not actually passing on ownership, you're passing on control. So then we need to look at the trust deed and set out, okay, well, on your death, who takes over that important role as appointor and has the power to substitute the trustee who then makes the distributions to the beneficiaries.
Okay. So it can be different for companies, different for trusts. Obviously, individuals, it's a lot simpler. So let's talk about, most businesses, well, hopefully businesses we act for have a shareholders agreement if there's multiple parties that own the shares of the franchisor entity of the business entity. So you mentioned that the shares aren't necessarily owned by the individuals.
Yeah.
So there's a shareholders agreement shareholders agreement often talk about death and disability in the shareholders agreement, and how does that interact with the will of each of the parties?
Yeah. So if you've got a really good shareholders agreement, and we were talking about this with clients yesterday, that the shareholders agreement you want to do once off, it's a bit of an arduous task, and you just put the document away for a rainy day. But death and incapacity is that time where you want to pull it out and see if it provides some guidance. So because it's your operating document, it's obviously going to talk about how decisions are made and all of that. But death and incapacity is a really critical point. So you might have a provision in your agreement that says that there's a compulsory buyback mechanism in place. So on the death of one of the shareholders, then the shares must be sold to the remaining shareholders at a market value, or you might have set out a different formula.
I think so. Rather than must be, often it's just an option, isn't it?
Yeah.
So it's a compulsory transaction, but the decision is at who can do it. Who can do it?
Who's buying it? So is it the company?
Yeah. Is it a put and a call, like it's sort of things? So it's like probably more common is that it's the company has not the party who's deceased.
Yes.
It's the other party.
Yes.
The one that survives, or they're running the business. They can force the estate of the party who's deceased to sell their shares.
Yes.
Yeah.
Because it makes, from a practical perspective, it's unlikely that it would suit the estate, the family of the deceased shareholder, to hop into business that they may have no knowledge about, no interest. But then you obviously want to make sure that they're not out of pocket and that they're looked after. So that's why putting into place this kind of mechanism just covers that risk.
It's interesting, isn't it? Because our example yesterday was a family-owned business, which is quite common in franchising land, that franchisors are a family business, and that's the legacy of the family business. And that I know we often have conversations with franchisors that there's a family, and there might be a shareholders agreement in place, even though it is between siblings or parents and children and things like that. But to deal with that situation, that normally if it was two independent people and they're owning a business, and that situation where one passes away, the other one has control of the decision making, and they can force the estate to sell.
Yeah.
But sometimes in family situations they say, no, my family are going to keep this.
Yeah, that's right.
And they want to have shares in this company. So,
that's right.
So it's something that you do need to consider. And it's you're talking to one party about their estate planning, but it flows through that having the conversation with the other parties, your shareholders.
Well, yesterday, in that example that you're talking about, what we were discussing is that, yes, you've got 3 shareholders, 2 of which are siblings, and they've inherited essentially the control of the business from their parents who set it up. Does there need to be separate rules for them, so that in the event one sibling passes away, does the other sibling get the first option to get the shares, so that there's some family continuity, or just recognition of the fact of how the business was built and that it is a family enterprise? So I guess the question then becomes, yes, we can have a mechanism in place that talks about buyouts, but how is this actually funded?
Well, I guess so I might just on the clauses. Yeah. So just how that practically it works, the shareholder. So if there is a death or disability, the company can either say we'll buy the shares, or the other shareholders can then buy them.
Yes.
And we need to work out a value.
Yes.
So
yes.
I guess before we talk about the funding, there's a valuation question.
Yes.
And so often shareholders agreements have things like good leaver, bad leaver type clauses. And so someone is a bad leaver if they're in default, but this is normally not carved out from that.
No, you don't penalise someone because they've died. It's a bit rough.
And so, it loops around in terms of, okay, so we need a valuation. So it's an independent valuation. And so again, there's been a tragic event. One of the parties parties to the shareholders agreement is no longer with us.
Yeah.
We need to look after their family.
Correct.
So the business needs to be valued, because in some situations it's the biggest asset. In lots of situations,
yeah.
It's the biggest asset they've got for the family is the business that they've been building. And so you need to do a valuation. And so that's why the shareholders agreement is important as well, because it sets out the rules around the valuation. Sometimes the valuation can be an agreed multiple that's in the shareholders agreement. Other times it's a market valuation that goes to an independent valuer. Again, something that costs money and takes time, but it is important that it is dealt with in the shareholders agreement, particularly when you're doing your estate.
Yeah, and that there's a process and a time frame so that it just keeps things moving rather than leaving the family and loved ones of a shareholder kind of in limbo, especially when the business asset is the main asset of the deceased. Yeah,
and I guess that's tricky because obviously the business isn't expecting to have to fund a buyout at a particular time, and so that's why the next point, which you raised, is how do we fund it? Who pays for it? Because one way is the shareholders pay for it because they do the buyout. They just happen to have the extra money lying around and they can fund it, but that's not always practical either.
No, that's right. So this is where insurance can be really handy. And there's different ways in which the insurance can be structured. So also we can talk about buy-sell agreements, which operate kind of and run parallel with shareholders agreements that talk about this particular thing. But basically, we need to work out the mechanics of who buys the interest at what price, the valuation formula, all of which you've said, the timeline, but the funding. So can be usually life insurance and TPD insurance. So, and those policies can be held by the business or cross-owned between the shareholders. So there's some different structuring around that. But basically, ideally, you're providing proceeds to fund this buyout. And in an ideal world, there's no gap, but there can be a gap sometimes.
So how is there a gap? Why does that exist?
Because the level insurance doesn't cover the valuation.
Okay. So you go in, the parties all decide to go and take out insurance. So like you say, it could be held by the individuals or it could be held by the company. And so there's different tax consequences of both of those. If it's held by the company, obviously the premiums are paid by the company. So you need to think about that. But then, so the gap, if the company takes out a policy and they say, we're going to insure the business is worth $4 million, there's 4 shareholders, so it's $1 million each. And then the business takes off. And so now 2 years later, the business is worth $10 million.
Yes.
So the policy's for $1 million. Everyone thinks that's great. They've been funding it. So what happens now?
So this is why it's a good idea to review your insurance policies as the business grows each year to see that the insurance levels that you have actually match what the estimated value of the business is. But where there is a gap, in some circumstances, there's nothing in the shareholders agreement that determines that. So then it's a matter of negotiating whether the deceased family is happy to accept less because it's something rather than nothing, or whether the shareholders have to reach into their pockets and bridge that gap.
So you mentioned buy-sell agreements. So sometimes you do see a shareholders agreement and a buy-sell agreement, and sometimes you don't, and these sorts of things are dealt with. So it could be, it doesn't really matter.
No, it doesn't. No. It can run parallel. Often shareholders agreements, you might set them up at the foundation of a business and you're not really ready to talk about
because you're all 20 years old and you don't care.
You're working hard, exactly. You're in great health.
And you've got no money.
And you've got no money, exactly. So you're certainly not going to take insurance policies out on each other. But later on, as you mature and the business matures, then the advice would be
to have kids.
And you have kids, yes.
And then you're like, who's going to pay for these little fellas?
Exactly. So you can continue with your shareholders agreement. If it doesn't contemplate these matters, we can do a separate buy-sell.
And the buy-sell will deal with these things around the policies.
Absolutely.
And the valuation and what happens if there's a gap and who pays for it and stuff like
Absolutely.
that. Yeah.
The only thing to consider is that now you've got another document as part of your estate planning kind of suite of documents. So you're going to have your will, you're going to have your shareholders agreement, but then you're going to have this buy-sell agreement that overrides the provisions of the shareholders agreement.
And so at the moment, we're talking to our accountant, our lawyer, because we need to get the documents. We're talking to our accountant because we need to understand the tax consequences of all this, and our insurance brokers.
That's right.
Yeah, and it is a really it is a sort of a combined effort really to make sure that this all works, because, and even the insurance brokers, you're actually potentially talking to different ones, because often the insurance broker who takes out your public liability insurance and your management liability insurance doesn't deal with personal insurances. And so lots of people have their life insurance through their super.
That's right.
And so, which is again, so you're talking just, you just get it through your policy.
Yeah.
So now you need to talk to a broker. But so often your insurance broker will have a contact, but it'll be a different person. So we, as the lawyers, you think you just get instructions to draft a will or a shareholders agreement, and it flows through into we need to have multiple conversations.
Yes.
Just to make sure that everybody's protected.
Yeah.
And hopefully once you do that once,
yeah,
you can set the framework, and there it's just a matter of checking your policy, your valuation of your business, and the policy that you're protected for match.
Yeah. No, this is certainly an exercise that it can't be siloed. You actually create a lot of risk and a lot of gaps and a lot of potential headaches by doing this in isolation with your accountant and then with your lawyer and then with your insurance broker. In an ideal world, everyone's talking to each other. Your accountants may have had may have been involved in setting up your structures. They probably know, where your shares are. Sometimes we've got clients who don't know whether their shares are owned in a trust or not.
Yep.
So we really need to be talking to them and then working together so that when it comes to the lawyers, and our job is to make sure that we're creating documents that are robust and set out your wishes, that we aren't unintentionally contradicting how assets are potentially held or other documents that are in place.
And so often in the shareholders agreement, it does deal with more than death. So it can deal with incapacitation. So there's clauses around that. So is that something that you're dealing with as well through the estate planning process?
Yeah, so I think when we've got clients who they want to do their will, at the same time we're also having conversations with them about powers of attorney, because it's all kind of related, and it's about thinking about who's going to make these decisions if you can't. Sometimes a lot of people think that get confused between a will and a power of attorney. Will is when you're gone. Power of attorney is when you're alive, but for whatever reason you can't, incapacitated, that's clear. But if you're unavailable, overseas, uncontactable. So we can do personal powers of attorney. So that's someone who can step in and make decisions on your behalf and, sign a contract of sale, for example, at an auction. But what's important to know is that with a business, though, you can't actually give someone a power of attorney to act on your behalf as a company director. So what you actually need instead is a corporate power of attorney, so that if, for example, if you're running a business and something happens to you, then you could face a situation when the business is frozen essentially and can't sign anything, can't do anything, because there's no one who has the ability and the right document in place and the right authority to make those decisions on your behalf.
Okay, so the directors, so we're going through an estate planning process, so they've come to see. So we're going to recommend a power of attorney now, so which could be their partner for personal matters.
That's right.
And it can apply when they're okay, just so then they've got it. So if they go away and they need to make for personal stuff, medically, that's a different thing. So if they need to make a decision, someone is incapacitated or can't do anything, there's a medical power of attorney. That's a different thing again.
It's a lovely title called an appointment of medical treatment decision maker.
Hey, that's good. Easy to remember.
Yeah.
So, and then the third one is the company. So if the person, in their estate planning said, well, I'm a director of 10 different companies, best practice is to actually have the companies have powers of attorney.
Yes.
Unless there's multiple. Like, I guess if there's multiple directors of your companies,
the risk is reduced.
The risk is reduced. So, but if you're a sole director of a company that's running a business and something happens to you, nothing can get done.
Exactly.
Because even if you've got a personal power of attorney with your partner, they can't step in and do anything because they don't have authority. Yeah, okay. So then it flows through to your shareholders agreement as well, who can step in and stuff like that.
Yeah. It's also worth looking at your trust deeds, because some trust deeds are better than others, and some were prepared in the Middle Ages and don't provide for incapacity provisions, so that what happens to the appointor if they become incapacitated. And in the absence of that, then you're going to VCAT to try and get orders for guardianship or someone to step in. So that's a lot of pain and suffering and time.
Cool. So there's a bit to think about for the business owners as they're getting all this sorted. what's some of the common mistakes you see that they're making? If they're trying to do these things by themselves.
Probably is just assuming that the will covers everything, which we've spoken about. It may not. So it's about actually, and we love spreadsheets, we love diagrams, but looking at what assets you have, how they're owned, what your structure is. So getting that right from the outset. Outdated documents, so a shareholders agreement that was drafted before you had investors come on, or that doesn't reflect how the business is operated, or is incomplete.
Or even a will before you have kids, or
correct,
or different marriage, or
marriage. Yep, that's right. So divorce marriage nullifies a will. So you need to make sure that these documents stay up to date with your personal circumstances.
And I guess that in terms of a will, a testamentary trust rather than a will is probably something that making sure that the assets, but so testamentary trusts are potentially to save from a divorce, like pass assets down through the family line. Is that one of the things?
Yeah, so a testamentary trust is similar to a discretionary trust, but it is only established on your death. And the benefits to testamentary trusts are the asset protection. So if you are worried that your children are going to be operating businesses in their personal name, you want to make sure that any inheritance that they're going to get is protected from that. Yes, to a lesser extent from marital claims, but also tax flexibility. So accountants love testamentary trusts, so that's another benefit. It probably depends on whether it's necessary. If you have a large estate in your personal name, then it might be best that a testamentary trust is established so that there is that tax flexibility. But if you're an operator and all of your assets are in trusts and companies and you've got shareholders agreements, what you might be left with in your personal pool is quite modest, in which case perhaps a complicated or a more complex will isn't really necessary in your circumstance. So it's about doing that exercise, which we need to do at the start of any discussion about your estate planning. So ensuring that there's succession for these important roles, as I said, in the trust, making sure that there's a mechanism in place that if you're the appointor and something happens to you, that there's that the document says who's going to take over in that instance. Unfunded buyout obligations, so where there might be a gap or no provision at all for how a buyout's to take place, and then all this good work that you've done in trying to protect your family and your loved ones is all kind of down the drain because it can't happen, or it might mean
on the flip side, the business is now dealing with an estate.
Yes, yeah, that's right, exactly.
And it could be one of the biggest shareholders, so you could say, well, now I'm in business with a grieving widow or someone that's got no idea about the business, that you need that have substantial shareholding in the business.
Yeah.
And you need to deal with it. So it's a big business risk as well as a personal risk.
Yeah, absolutely. Siloed advice, as I said, so where things are missed because your advisors aren't talking to each other. And probably doing nothing, thinking that, I'm not at the age yet where I need these documents. I'll do it in the future, I'll do it next year, and not actually getting around to it, because dying without a will it's a headache. And what people need to be mindful of is that there are provisions that are legislated that actually dictate who receives your personal estate in those circumstances. And most of the time it is people who you might want to receive your estate, like your nearest and dearest, whether it's your partner, your children and all of that. But what you'd be deferring to is a piece of legislation which might not actually, reflect your wishes. And that's, a headache for the people that you're leaving behind too, just administratively too.
So would you recommend ChatGPT or Claude does your will?
Yes, I've seen quite a few examples of ChatGPT wills, and good try. But look, it can be helpful just to put on paper what you want. I haven't yet heard of a circumstance where someone's passed away and all they've got is a ChatGPT will on the computer, and whether that's sufficient enough to, try and get a grant of probate or letters of administration. But wills are they're documents that have existed for a long period of time. They're documents that need to be prescriptive. They need to be clear. They need to be devoid of any ambiguity. And also the laws around wills and estates, unlike kind of the modern world, we still, for the most part, need to sign wills with wet ink. You know, it's pretty old school. You need to use the same pen. You need to make sure
is that partly because you want to make sure that the person that's signing it has the capacity to actually do it?
That's right. Yeah. That's right. And you want to make sure that it can't be argued that there was a missing piece to the will, and so it's
because I know during COVID that was a bit tricky, wasn't it?
And then look, that was, I guess, an example where legislation did change, and we progressed into the future, and we were having will signings over Zoom. But I think for probably most practitioners, I imagine, would still prefer wet ink, just because that's what's been drummed into us from the get-go.
Cool. Well, we know that Claude and ChatGPT can just shareholders agreements because we've seen some good examples of that. So maybe it'll evolve and we'll be able to do wills next. So look forward to that. But in the meantime,
give us a call.
Talk to lawyers and accountants, and hopefully.
And the powers of attorney and all of that, the witnessing requirements are like pretty stringent. So lawyers do need to have a role. Got a job. Yeah.
On that note, thank you very much. Thank you for coming in, and thank you everyone for listening to our BDC Partners podcast. If you enjoyed it, remember to like and subscribe. Thank you.
Bye.